matter of if you need to get set up with the interpreter, she's all set.
She's been received it from the interpreter. So
Very good. All right. This is the matter of State versus Michelle Troconis. Would counsel please identify themselves for the record?
Richard Colangelo with Dan Cummings for the state, Your Honor.
Good morning, Your Honor.
Good morning, Your Honor. Attorney John Schoenhorn representing Michelle Troconis, who's standing to my right.
All right. Good morning, counsel. Good morning, ma'am. You may be seated.
Your Honor, if I may,
Yes.
just for the record, I provided counsel with any of the outstanding discovery that he was looking for this morning. I also provided him, we filed with the clerk's office first, copies of the long form information. I provided counsel with a copy of those. I put a copy on your bench, Your Honor, for you, so you have the long forms in this case. I know that we're here to address counsel's motion for the conditions of non-financial conditions of release. Before we start that, though, Your Honor, I'd like to make an oral motion for sanctions against Attorney Schoenhorn for violating Connecticut Practice Book Section 40-10 with custody materials. I will note that the motion that he filed with you was sent to media outlets at, 4 different emails are sent with attachments, 11:05, 11:13, 11:18, 11:23 on August 25th. And then this motion was ultimately filed with the court, and I got a copy of it at 2:53. So, pursuant to our discovery that we provide to counsel, we indicate that he is not to copy or provide any of the information we give him without permission of the court or us. That's also part of the practice book session. Counsel took it upon himself to send out the things that ultimately made it into the media. Violations of, again, Your Honor, right, conditions, practice book sections. Probably his oath as an attorney about being candid with the court and getting this information and providing the information to co-counsel, or opposing counsel, sorry. He didn't provide me the ability to object to anything that he was getting out into the media. So I'll just leave it at that, Your Honor, but I believe that sanctions are appropriate in this matter because this is the attorney that's out there commenting on the media coverage from the New York outlet and how his client's not going to get a fair trial here in Stamford. And then he goes and does the stunt that he pulled on the 25th. So I wanted to start with that before he started with his motion, please. Thank you.
Would you like me to respond to?
Yes, we were here. I was initially under the impression we were going to hear your motion to modify the non-financial conditions of release. I know there are other motions pending, but that was what the court had set aside time for today to hear. But this is news to me, that what the state's alleging now. I am aware there was some disclosure last week, or not last week, earlier this week, with respect to certain videos that were released in the paper, but you may be heard.
Thank you. And I'll note that Mr. Colangelo did not even have the courtesy to tell me that he found anything that I did improper. So this is the first I'm hearing of it. I didn't realize that it was going to start off this way, but I'm going to preface this by saying that I'm expecting Mr. Colangelo to apologize because there was nothing released to the video that was not attached to my motion as an exhibit. There was no order that if something was filed with the court that I could not, at the request of the media, then give them a copy of what I filed. There is nothing, and I want to emphasize, and I'd like to take my mask up to do it, but I won't. There is absolutely nothing that was released to the media that is not attached to my memorandum of law, including the 3 videos which were filed with the court. Therefore, there is no violation of anything, and for Mr. Colangelo, and I should point out, nothing was released until after it was received by the court, because I had it sent by priority mail, and I tracked it, and I made sure that nothing was released until after it was received by the court. And a copy was received here at the same time by the state's attorney's office, and I don't have that portion with me. I could probably find on my cell phone the exact time it was received and signed for by the state's attorney's office here in Stamford. So not only is what Mr. Colangelo said absolutely false, I'm just shocked that he would make that kind of statement when he full well knows that there's no violation of anything that in regard to the practice book, and certainly nothing that violates any order of this court. Therefore, I expect Mr. Colangelo to apologize and since he did this just as a stunt, and I will emphasize it's a stunt, that I'm going to ask that the court take sanctions against him. And that's my response, Your Honor.
Just briefly, if I may, Your Honor, counsel is correct that anything that he files with the court can be released through the court. That is not what happened here. The counsel took it upon himself to distribute this to the media without prior court approval or court. So if the media wants to come and get something that's filed with the court, they come to the clerk and they get copies. That's not what happened here. That's not what counsel did. That's the violation that I am talking about. He didn't give the state the courtesy to say, hey, you know what? This is an incomplete video. We should include this. Or I'm going to object to that. And as far as discovery goes, Your Honor, the information that he signed, the paper that he signs from my office, he can't disclose, distribute, or hand out anything without my prior approval. So whether it's attached to a motion or not, he's correct. If the court disclosed this information, if the people got the information from the court, then I wouldn't be standing here and asking for this. But counsel did it via email to the media, multiple media outlets apparently. I found out about the motion through the media before we got it here in court, in this courthouse. Thank you.
I'm going to take the cross motion for sanctions under advisement. I'd like to get to the merits of the arguments with respect to the defense motion to modify the conditions of release. I did receive yesterday the latest progress report, status report on the defendant's compliance. Copy of that?
I do, Your Honor. Thank you.
Great. Counsel, for the sake of the clarity of the record, your memo lays out, and I'd like to address them if you could for clarity individually. You're seeking the following modifications. One, reading from the first paragraph of your brief. Removal of an ankle bracelet in place since June 2019. Number two, removal of all GPS monitoring. Number three, termination of participation in the intensive probation program. 4, termination of house arrest and other curfew requirements. 5, removal of travel restrictions within the United States. And finally, 6, prohibiting any requirement that she report to probation officer or other CSSD official while on pretrial release. And to my thinking, counsel, I believe that the IPS program, the Intensive Pretrial Supervision Program, is what includes that type of reporting. So those two are closely related in the report's mind. But for purposes of clarity, the court would appreciate if you could address your arguments. And I don't care what order you go in, but if you could address them so the court can take your arguments and the counter-arguments of the state into advisement. I'm going to issue a written decision. I expect to get it out shortly, given the importance of these issues to the parties. But if you may proceed how you wish.
Thank you, Your Honor. I had intended to rely principally on the memorandum. I tried to, instead of taking up the court's valuable time, I tried to just set forth all the potential issues that I could argue. So unless the court wishes me to, I will not argue the practice book or what the statutes say. I think I've set that forth. So I guess the only things that I would want to say are this. Whether or not it was appropriate originally for any of the Superior Court judges that entered orders, whether they were in Norwalk or here, regarding those conditions and whatever purposes they served back then, as of today, as of August 28th, they are no longer required, they're no longer necessary, and therefore we're asking that the court remove those conditions. Mrs. Troconis' father, just last week, was released from intensive care. He came down with a serious, severe case of COVID. He lives in Florida, Miami, Florida. Of course, she couldn't visit him while he was in the hospital, but he's now released and he's at home. He's now finished with his quarantine and he's recuperated. So her sisters have gone to see him. She hasn't been able to see him in quite some time. And that's one of the more recent things that I didn't even get a chance to put in the memorandum that is a concern as far as these conditions are concerned.
Has she made a request to travel through probation? Because I know recently she was allowed to go to Bradley to pick up her daughter at the airport, and the court had no problem with that. And She has been compliant. The record should reflect. She has been compliant since these conditions were imposed.